morning, everybody. This is the Colorado Oil and Gas Conservation Commission. It is Friday, September 3rd. It is 10 a.m. and we are taking up a continuance of docket number 2103-00016 in the matter of the application for front range nesting bald eagle studies for a petition for review. To begin, we will take the roll.
Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez.
Here.
Commissioner Hackett, Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Naijaba.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Great. Good. Well, good to see you all this morning. We've got approximately 20 participants with us. And so I think we're set to go with deliberations. We undertook evidence and testimony on, Wednesday, September 1st. And then the day got away from us and we were not able to entertain deliberations. And so I think that that's where we are now. And I don't think we need to do anything further. Looking to AAG Davenport to make sure that I'm correct in that analysis, that we can just move straight into deliberation.
That's correct. My recollection is also that the commission did close the record, but made it clear that that was not for asking council questions. So it's open for asking council questions as well.
Okay, and I'm looking.
Though not required to ask
Right.
council questions.
So just to be fair, there's a cat behind you, Priya. To be fair, why don't we go ahead and raise Ms. Perdue and Ms. Jost as panelists, since we already have Ms. Stafford as panelist. And that way, if there are questions, we will have them available. Not that we have to have questions, but that way we can just sort of have the 3 council of record before us. With that, I would look to my fellow commissioners to see if anyone wants to start in terms of presenting their thoughts with regard to deliberation. Commissioner Naijaba.
I'm prepared to share my thoughts. I just wanted to make sure that there were no commissioners that had questions for the council, for our various party councils.
Any questions, commissioners?
Okay.
I'm not seeing any. So Commissioner Naijaba, do you want to lead off with thoughts?
Sure. Thank you, Mr. Chair. And thank you all to all the parties for coming back again today to appear before us and to listen to the deliberations. You know, this was, I will just say that, you know, for me as a wildlife biologist, you know, this was something that I thought a lot about. You know, I care a lot about the matters that were, the concerns that were voiced. And, you know, this was very difficult to kind of really understand all the details and the facts. And the challenge is that, you know, despite my own personal feelings and what I may want as an outcome on a personal level, obviously my role is to look at the facts, the details of the rules at the time, and the jurisdictional considerations. And one of the things that, you know, that I have learned in my policy work over the years, and that I often say to other, you know, colleagues, is that, you know, governmental entities, and this was something that was shared by AAG Stafford and others about, you know, governmental entities are creatures of statute. And so we have to follow what the statute says, what the rules say, etc. So given these things, what I find is that first, the language in the Act regarding the definition of oil and gas operations is not explicit when it comes to the movement of water, of fresh water in particular. Although it discusses flow lines and the movement of production-related materials, it only mentions exploration and production wastes. And where flow lines is noted within the definition of flow lines, it specifically for offsite flow lines, it notes in particular that freshwater piped to the site is not a flow line. So A&W pumping water at the Stromquist pond that's piped to a holding tank on the pad. They are not pumping water directly on the pad to the well. And while I completely agree that a contractor of an operator is absolutely responsible for following the rules, I think it matters where that type of operation is occurring, and the rules associated with per the statement of basis and purpose from our recent mission change rulemaking, Rule 423 does apply to existing facilities, but our definition of an oil and gas facility means equipment or improvements used or installed at an oil and gas location for the exploration, production, withdrawal, treatment, or processing of crude oil, condensate, E&P waste, or gas. And then further, our definition of oil and gas location means a definable area where an operator has disturbed or intends to disturb the land surface in order to locate an oil and gas facility. So with that, my conclusion is that the pumping location was not an oil and gas facility or an oil and gas location, and therefore falls outside of COGCC's jurisdiction. Further, I note that eagles are no longer listed as threatened or endangered under the Endangered Species Act, and so the U.S. Fish and Wildlife Service also does not have jurisdiction. CPW lists them as a species of special concern, but this carries no statutory designation or protections. Despite all of this, once concerns were voiced to Crestone, they did take additional measures in consultation with CPW to minimize impacts. They conducted several surveys with the third-party wildlife consultant. They observed pre-construction eagle behavior and post-construction behavior. Those COAs, the conditions of approval, were applied from the January 2019 Form 4 that they had filed following consultation with CPW, and that resulted in daily raptor surveys through January, and then subsequent weekly surveys in February and March. So with that, I believe that Crestone undertook more than they were required to do in order to try to best protect these eagles and to ask of the subcontractor to minimize disturbance as best as possible. But with that, I find that this is not a matter within our jurisdiction, and therefore I believe that Director Murphy acted correctly and did not act erroneously in this matter.
Thank you, Commissioner Naijaba. Commissioner Messner, then Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Commissioner Naijaba, for sharing your thoughts. I think I came to a little different conclusion, and so I'm going to read some of my thoughts and the conclusion that I came to. So this is a little lengthy, so I apologize in advance. So CRS 3460-106-2A and B provides that the commission may regulate, and I'm paraphrasing here a little bit, may regulate the drilling, producing, and plugging of wells and all other operations for the production of oil and gas, as well as the stimulating and chemical treatments of wells. Section 106.5 similarly provides that the commission shall regulate oil and gas operations in a reasonable manner to protect and minimize adverse impacts to public health, safety, and welfare, the environment, and natural resources. CRS 3060-103-6.5, oil and gas operations means exploration for oil and gas, including the conduct of seismic operations and the drilling of test bores, the siting, drilling, deepening, recompletion, reworking, or abandonment of oil and gas wells, underground injection wells, or gas storage wells, production operations related to any such well, including the installation of flow lines and gathering systems, the generation, transportation, storage, treatment, or disposal, exploration, and production wastes, and any construction, site preparation, or reclamation activities associated with such operations. In this situation, we have water that by right and quantity is specifically being diverted from Idaho Boulder Creeks and/or Philly Ponds to Stormquist Pond for the use on the Dreamweaver pad and on the Dreamweaver pad only. A subcontractor of Crestone A&W then pumps and pressurizes the delivery of this water at a location that is approximately 400 meters from the edge of the Dreamweaver well pad to the well pad site. It is clear through evidence and testimony that this water is to be used solely for the completion of wells on the site and has no other use. The pumps and associated laydown pipe are directly connected to the Dreamweaver pad and to no other use or operation. It also appears through testimony and evidence that this pump and laydown pipe associated with the Dreamweaver pad is on the same surface owner's property as the Dreamweaver pad. Due to the proximity to the well pad, the water right associated for use specifically for this oil and gas operation, and the direct connectivity of this associated use, which in my opinion is a storage and compressor station for fluids utilized in completion activities associated with the Dreamweaver pad, I do believe that in this narrow and specific instance, the COGCC does have jurisdiction over the activities and impacts associated with this site. I do believe that CRS 3460-106 does give the Commission the authority to regulate the drilling, producing, and plugging of wells, all other operations for the production of oil and gas. The shooting and chemical treatment of wells and oil and gas operations so as to prevent and mitigate significant adverse environmental impacts on any air, water, soil, or biological resource resulting from oil and gas operations to the extent necessary to protect public health, safety, welfare, and including the protection of the environment and wildlife resources. I also believe that in the completion activities, I do believe that the completion activities are contemplated in the definition of oil and gas operation activities, particularly because the utilization of the term recompletion in the definition, which in turn contemplates previous action of completion. I reemphasize that the specific characteristics of this instance create a narrow applicability of COGCC jurisdiction. Should the water being used for this operation not be solely tied to this operation and within 400 meters of the site, should the water rights and volume not be directly and solely associated with the operations on the Dreamweaver pad, or the associated infrastructure not be solely tied to the operation on this site, then I believe the argument that this would not be an associated operation to the Dreamweaver pad, that would not be an associated operation to the Dreamweaver pad, and COGCC would not have jurisdiction could hold true. But the specifics of this case, I believe, lend itself to an affirmative showing that this is an associated and ancillary operation, and COGCC does in fact have jurisdiction. I will note that it is a historical and current practice of the Commission to regulate truck traffic on access roads to oil and gas sites to avoid, minimize, and mitigate impacts to public health, safety, the environment, and wildlife, and trucks carrying water for the sole purpose of use in oil and gas activities on site would fall under the jurisdiction and regulation of the Commission on these surface access roads on the vicinity of the site and not just on the site. I will also note that Crestone has and does utilize best management practices to avoid, minimize, and mitigate impacts due to noise and standard operation, and has done so on the Dreamweaver pad. A simple solution to this issue would have been to just utilize these tried and true methodologies in this instance, rather than attempting to find loopholes in the rules to not have to address this situation. Proactively addressing and avoiding, minimizing, and mitigating these types of impacts, even to the point of going over and above what is expected, is often stated as a standard operating procedure for good operators, and in this Commissioner's opinion, would have been the correct approach to this situation, so we would not have been here today. It is also confusing to me why CPW would recommend timing limitations on activities associated with oil and gas activities at this site to avoid, minimize, and mitigate impacts to bald eagle roosting activities in 2020, and then remove these limitations to minimize impact the following year. The sad fact is that the associated activities do seem to have a negative impact on the bald eagle roosting area at this location. This commissioner's remedy would be to remand this back to the director to address this situation as she sees appropriate, understanding that in this commissioner's opinion, that in this narrow instance, the COGCC does have jurisdiction over this activity.
Thank you, Commissioner Messner. Commissioner McGowan.
Thank you, Mr. Chair. And I'm so appreciative of these different viewpoints and everyone's expertise and how they're looking at this whole issue. So I took a little bit of a different, I skinned the cat a different way, I guess. And I started with what the violation was, or the alleged violation, which was the noise, the violation of the noise activity. And I think it's pretty clear that based on the information that, for me, that the director had, that there was no violation either of the under the old rule or the new rule for noise. And so if there was no, regardless of whether A&W is an oil and gas operation, if there is no noise violation, it doesn't really, I'm not going to say this right, I don't think then it becomes relevant whether or not A&W is part of oil and gas operations. And so I'm starting with, I don't find that there was a noise violation under our rules with the data that was submitted by FRNBES. And so I stopped there, but if the commissioners want to head into further than that and think that there was a violation, and therefore we have to then consider whether or not A&W is an oil and gas operation, I am prepared to also have that conversation. I will say, I thought it was disingenuous for Crestone to say that A&W was a contractor for which is solely a third party that they had no control over, that there was no association with. There's an email from Mr. Tewksbury saying, we will make sure work is done only in the 10 to 2 p.m. timeframe in regards to A&W, which to me implies a direct relationship and oversight to those activities. And I'm gonna stop there because I stopped at the noise violation, and I'm not sure that I need to even get into whether or not A&W is an oil and gas operation then. And I don't think that there was any clearly erroneous decision from the director based on the noise information. I have lots of opinions about what was happening to the Roost site.
Thank you, Commissioner McGowan. Commissioner Gonzalez.
Thank you, Chair, and thanks to my fellow commissioners for those thoughtful statements. First of all, I really appreciate the work that Front Range Bald Eagle Nesting Studies is doing. I think that the wildlife in our state is an important component of just being in Colorado and what this state means and what we have here. And so I appreciate those efforts and those protections that the agency is seeking, Front Range Bald Eagle Nesting Studies. What it came down to for me was two things, and I thought that I reached them pretty clearly. And the first is on the jurisdictional question, which I do not believe we have jurisdiction. I'll go into that in a moment. And I don't believe that the director clearly erred in her decisions through the investigation, the extent of those investigations, the application of the rules, or in her decision to close the complaint. So that's kind of the bottom line of where I fell after hearing all the testimony, after reviewing everything in the record, and hearing the presentations from counsel. As for the jurisdiction piece, I think that the way the statute is written requires some reasonable interpretation of what are oil and gas operations. And I think there are some enumerated aspects of oil and gas operations that are listed in the statute. And I think those are important to consider in determining how to interpret that definition of oil and gas operations. And I think that there are times when perhaps that interpretation may go beyond just what is clearly and explicitly stated in that statute, again, within reasonable limits. In this case, I don't think that the activities of A&W are within that interpretation, because I think that what was happening here was a sourcing of materials for oil and gas operation and was not in itself an oil and gas operation. And I think that if we consider kind of, or my consideration of what that line means, I think that when you're sourcing materials, when you're bringing them onto site, there's a lot that goes into it upstream of an oil and gas operation. And I think that if we were to consider sourcing of those materials, I'm concerned about how far upstream that may go and how far removed from the direct and contemplated oil and gas operations in the language of the statute could be applied there. And I think that there's a slippery slope that I'm concerned about if we start looking at the sourcing of materials versus for an operation versus the actual operation itself. So in terms of the jurisdictional question here, I don't think we have jurisdiction because I do believe that this was a sourcing of materials to site where it was then staged, where it was then used in an oil and gas operation versus this being an actual oil and gas operation itself. So that's kind of the crux of the matter for my determination on the jurisdictional piece. Again, I reviewed through the record what the actions of staff were through their communication with Crestone, the consultation with CPW, the application of best management practices and the associated forms thereof. And I think that when I'm looking at it, I can't find that the high hurdle of clearly erroneous has been met as that burden stands. And so to bottom line it, I do not find that the director clearly erred in her decisions surrounding the investigation and the closure of the complaints themselves.
Thank you, Commissioner Gonzalez. I am in like mind with the rationale as articulated by Commissioner Naijaba, which I believe you tend to agree with as well to a certain extent. And I sort of start and finish my analysis with the clearly erroneous standard and with this commissioner at least position that generally speaking, I think that high standard is important because I generally do defer to the director and to our expert staff in terms of analyzing alleged violations and making determinations of whether to prosecute or not. I think that is very much within the bailiwick of our staff, the expertise that they bring to this. They have a whole fleet of environmental protection specialists. And so I would defer to them. I think there's ample evidence in the record to support their conclusion that in this case there was not jurisdiction. And so I would agree to the concept of, at this point, dismissing the petition at this point. I do want to note that I too appreciate the work of the Front Range Nesting Bald Eagle folks. I had some interaction with them when I was director and appreciated their work and the lens that they're bringing to this. I also want to note that I appreciate that once this issue arose, staff jumped into it, CPW got involved, Crestone got involved, and I appreciate the fact that there were some action items to try to alleviate the issue. So I think there was good work all the way around, but that is sort of where I land as well. If I can count right, I believe that is a 4-to-1 position from commissioners relative to dismissing the petition. I would ask AG Davenport to maybe weigh in here in terms of, we've never done this, so what do we need to do? Do we need to articulate all the rationales again, or is the record sufficient for there to be a creation of a written order? Do we just take a vote, or what? And I also do not want to foreclose additional dialogue amongst my commissioners.
Thank you, Chair. Commissioners, at least in my view, the record that you've created is sufficient to create a written order memorializing your rationale, should it go in that directly to a vote right now. Of course, that shouldn't preclude from stating any additional rationale. You may make a motion at any time in regard to the petition. The written order will be following subsequent to this deliberation today. It, pursuant to statute and our rules, must be issued within 30 days of today. And it's when that written order is issued that this action becomes final for purposes of any judicial appeal. That written order will memorialize the rationale stated here today, all of the rationale stated here today in regard to whatever your vote is.
And that written order would be on an agenda, a consent agenda or something like that at an upcoming hearing?
Yes, you may review that written order before it becomes a final order that's issued.
Okay. Thank you, AG Davenport. Is there further discussion, deliberation amongst commissioners? Commissioner Naijaba.
Not really further deliberation, but I just wanted to note the unfortunate mapping error that I think also kind of led to some of this becoming an issue. As I understand it, and again, while I may not like it, the mapping error is what we are bound to. The maps, related to high priority habitat or to at that time frame sensitive wildlife area was incorrectly mapped, but that is what we have to follow for our rules. And so that was another point of this that was difficult, but I feel that is an aspect related to how we consider matters like this going forward. I do note that it currently falls within high priority habitat. The entire site does now. And so I'm happy to see that that mapping error has been fixed for our current set of rules. I also just want to acknowledge the rationale that Commissioner Messner made, because I was kind of going in a very similar direction, but ultimately I did feel that there were some potentially unintended consequences in doing so, and so I landed at the conclusion of our lack of jurisdiction in this particular matter. That said, and to the extent that Crestone can continue to ensure that operations such as this that are in these types of habitat areas can be considered for minimization of impacts, I think would be very important going forward. And then lastly, I just want to also acknowledge and meant to say that I do as well appreciate all of the work that Front Range Nesting Bald Eagle Studies has been doing, and that I look forward to their input on future matters that come before us in the commission. So thank you.
Thank you, Commissioner Naijaba. Commissioner McGowan.
Thank you, Mr. Chair. And I echo everything that the commissioners have said. For my part, just because I'm looking at this violation, I guess, from a different perspective of commissioners, I do want to be on record saying that I do think the definition of operations is one that should be looked at with an eye toward, among other things. I don't think that that list is exclusive. I don't think it can possibly cover everything that we regulate as far as oil and gas operations. And I think that we're going to be looking at these types of things on a case-by-case basis, because I don't think that there's a one-size-fits-all in the statute or our regulations. And so I'm sure that this will be not the last conversation we have about whether or not it's inside the box or outside the box. But I really appreciate everyone's efforts and all the information and the expertise that was shared.
Thank you, Commissioner McGowan. I echo that thought, that the list is not exclusive relative to the enumerated items that could be considered oil and gas operations, and each factual scenario needs to be adjudicated on its own basis. All right, any further thoughts? Otherwise, I believe that we are looking for a motion to deny the petition for the, on the basis of the discussions as set forth by commissioners this morning.
So moved, Mr. Chair.
We have a motion. Do we have a second?
Second.
We have a motion and a second. Any further discussion?
Mr. Chair,
Commissioner Messner.
so I am going to vote in opposition to this motion, and I'll just state for the record, the reasons are the reasons that I gave in my explanation, and still believe that those hold true.
Thank you, Commissioner Messner. I completely understand. And for that, noting that, I would like to take a roll call of commissioners as opposed to a vote, vocal vote. I think that would be more appropriate in this instance. So I'm putting Ms. Larson on the spot. Commissioner McGowan?
So, thank you, Mr. Chair. I just want to add to what Commissioner Messner said. I am voting to dismiss based on the fact that I think there has been no noise violation, not because I think that there's a jurisdictional issue.
Any further elaboration on the votes from folks? Because what we're doing is we're giving Kyle the things he needs to put into his written order. With that, Ms. Larson, if we could do a quick roll call.
Certainly. Commissioner Bogue, Commissioner Gonzalez,
Yes.
Commissioner Hackett, Commissioner McGowan,
Aye.
Commissioner Messner,
Nay.
Commissioner Naijaba,
Aye.
Commissioner Robbins.
Aye.
Mr. Chair, the motion passed by a vote of 4-1.
Thank you very much. So thank you all commissioners for the thoughtful deliberations. I also want to thank the attorneys for the parties that participated before us. I thought that the attorneys did a very good job of articulating their clients' positions. I want to particularly thank Ms. Perdue and Ms. Kane, who've not appeared before us, or if you have, I'm not aware of it, but I thought you did a great job. Hope to see you again at future matters. And with that, I believe that our business for today is through. So I think we're looking for a motion to adjourn.
So moved.
Second.
We have a motion and a second to adjourn. All those in favor signify by saying aye.
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 Any opposed? Great, folks. Have an enjoyable and safe long weekend, and we will see you back next week.
Thank you, commissioners.